Inclusion.
No, yesterday a matter was discussed in which my name spelling came wrong.
এই কিছু অর্ডার দিতে হবে না, করে দেবে, খুলে করে দিতে পারবে ওটা।
সই হয়ে গেছে ওটা,
সই তো হয়ে গেছে, কাল
Lord, may I have my Lord's kindly to mention the matter?
after the physical mentioning. NDPS কি 50,000 থেকে না 25? হ্যাঁ, bail bond normally it's 25,000. No, sorry, that is in all NDPS cases. We are not going to change that. No. Sorry, next.
My lord, inclusion of the list.
Yes,
So may I want to mention a matter for inclusion in the list?
inclusion.
May I have my Lord's kindly?
Yes. Yes, Mr. Basu.
Order 41 matter, my Lord. The next date for police help is on the 12th of November.
Yes, you want inclusion or upgradation? What do you, is it in the list?
It's not in the list at all. My Lord, it may be heard this week because 12th is the date for execution.
Give the number, let it be listed.
Yes. My junior is there. Yes, my junior is there.
Let it be listed. Now, number 10 niye list kore dao.
I'm grateful.
Order 41.
I'm grateful.
How do we get the number?
My junior is there. He's going to hand over.
Nobody is here. You are junior. Are you assisting? Any of you assisting Mr. Basu? No.
Yes. If it's Mr. Basu, then this is for the inclusion. In the
Yes. No.
We did not.
Yes, all right.
I'm grateful, madam. I'm grateful.
কেন এসছে এটা? করে দিতে করে দিও, অর্ডার দিতে হবে। This appeal has been erroneously registered as FMAT. Stop. It should be registered as FAT. Huh? Stop. Let the needful be done by the department.
Thank you, my lord. May I submit one thing, my lord? Yesterday's matter, some of the matters, my lord, date has been incorporated as 4/10/2024. In place of 4/11/2024.
Bojo.
Some of the matters. Some of them. Number below the beach.
Can you tell us which matters?
Yesterday's matter, item number 13, 21.
দেখো, হ্যাঁ দেখে নাও।
I'm checking and
Please,
give them the number.
Please. এই অর্ডারের ডেটও যদি আমাদের চেক করতে হয় তাহলে তো মহা মুশকিল হবে। কি বলবো বলো, আমাদের যদি অর্ডারের ডেটও চেক করতে হয়, যে কটা আছে সব তুমি মেনশন করবে।
Give the numbers. Give the slip.
Lord, do I appear for the petition?
Two, yes.
Yes. Lordship, this is the last order which was passed. Oh.
But we granted
Lordship,
yesterday.
Yesterday, yes. Similar matter, SLP has been referred.
Yes.
My lord, my.
Do you have a copy of that order, yesterday's order?
Yes. I apologize, I have only one comment. The second judge is.
No, not, this is not yesterday's order.
Yesterday's order.
This is Justice Boshak's order.
Please watch. কালকে সিমিলার ম্যাটার কালকেরটা করব আরে
Get a copy.
Yes, কালকের
Pass over, huh? Oh.
My lord, these are the orders, not at all.
কেন কালকে তো সই করে দিয়ে চলে গেছি। You've got it? তুমি বলছো আপলোড হয়নি, অর্ডার দিচ্ছে কি করে? Your SLP is in Kabir Vishwas case. So it will be the same order.
No. This is different case, two days case. That was the previous case. Two cases, the SLP was two separate matters, my lord.
Yes, I understand. But you are claiming parity with whom?
My lord, with Babar Ali and Podimal Raj. In this matter too, my lord, the state has preferred an SLP. The order that I am showing to your lordships is a different matter, but similarly placed, wherein an SLP was also preferred.
I see. Isho? The petitioner claims parity. So he says that co-accused persons, namely,
My lord, Babar Ali and Podimal Raj.
Ligecho, were granted bail by this court.
Yes.
Stop. He says that he stands on the same footing as those accused persons. Paragraph, learned advocate for the state, comma, while opposing the prayer for bail, comma, in his usual fairness, comma, does not dispute that the petitioner is similarly circumstanced as Babur Ali and Namta. Stop. Learned counsel further says that a special leave petition. Do you have the number? No. Doesn't matter. Has been filed by the state against the order passed. That was one order granting bail to two persons.
2%.
One order, same.
One order. Well, two different orders.
Two different
Two
orders.
different orders.
Then you have filed one SLP or two SLPs?
One SLP. The order of Justice Boshak says. Well, Lord, the SLP that has been preferred is for the original order, which is 24th of July 2024, my lord, page 25 onwards. The state has preferred the SLP against this order. Podimal Raj.
You will know.
Against Podimal Raj. Page 25 onwards.
ওই দুটো লোকের নাম কি ছিল এখানে বাবর আলী আর আচ্ছা কি বললাম by a coordinate bench granting bail to Porimal Rai. Stop, however, comma, as of date, comma, there is no order of stay from the Honorable Supreme Court. Paragraph, hence, comma, on the ground of parity, we allow the petitioner's prayer for bail. Accordingly, will be same condition.
I'm deeply obliged.
Not today.
I'm appealing for the state. I'm for the petitioner.
NDPS case, petitioner is languishing behind bar for more than 1 year, my lord. There was no possession from the present petitioner. The contraband was recovered from the truck of the co-accused, my lord. And
How,
there are-
on what basis have you been implicated?
since I was talking with the driver of that truck, my lord, the co-accused, and we exchanged biddies with each other. So on suspicion, my lord, I was
No, it was recovered from the vehicle
of the another truck,
of,
the co-accused truck, my lord.
it was, in which vehicle you were sitting? In another vehicle?
Yes, my lord. There was one truck, my lord,
May I?
Yes,
one truck and one, my lord, mini van.
May.
Yes.
But actually, my lord, the fact is that, my lord, in front of a line hotel, two trucks were parked there. And the contraband seized from the car bearing number, truck bearing number, my lord, NL01 AD 1747, the truck. And the driver of that truck, my lord, is Mohammed Rakib, the another accused person. And my lord, and another Mahindra pickup van also parked there.
I am
Jamshed Alam, this petitioner, is the owner of that truck.
Driver of that truck.
Driver of
So,
that truck.
question is the contraband seized from the vehicle, the petitioner is neither driver nor khalasi of that
Yes,
vehicle.
yes.
Or not neither the owner of that vehicle.
Neither of the owner and neither the driver.
Neither owner, neither driver,
Neither.
nor the khalasi or
Yes,
whatever
yes,
it is.
yes.
So
He
his
was, he
car-
was, he was the driver of the another.
another car which was standing behind.
Yes, yes.
What is
But,
this?
as per seizure list, my lord, joint one.
No, it's
As
a
per-
vehicle is different.
Vehicle is
He's
different.
he's
That-
not in
that's-
that vehicle also.
My vehicle is also been
The
seized.
contraband recovered from that vehicle,
What
that
is the
truck.
stage? What is the stage?
My lord, only charge sheet submitted.
Charge sheet was submitted, my lord,
Charge sheet
without
submitted,
SSL, my lord.
When?
14th of April 2024, charge not framed yet.
More than 1 year.
More than 1 year, my lord. And charge sheet was filed without SSL, my lord.
But my lord, seizure list says,
Second charge sheet was filed,
second charge sheet
supplementary,
filed on 31st of May 2024.
which was beyond 180 days.
Beyond one.
So the FSL report was filed beyond 180
Beyond
days.
one.
When you filed the first charge sheet, there was no FSL
No
report.
FSL.
Then what happens? What happens according to the division bench of this court? He becomes entitled to statutory bail.
That's true. Your Lord. But the contraband is huge quantity, my lord, and as per seizure list,
Sir, why don't
Yes,
you follow
yes.
the rules, follow the law? We
Yes.
have no sympathy for criminals.
yes. Yes.
I should say it. The petitioner says that there was no recovery from his possession. Stop. He is the owner of a Mahindra van which was parked behind the truck from which recovery was made. Stop. He is in custody for
More than 1 year.
more than 1 year. Stop. Beyond filing of charge sheet on
14th of April 2020.
April 14, 2024, nothing has progressed in the trial. Stop. He prays for bail. Paragraph. Opposing the prayer for bail, learned State Council tells us that 2
Joint
kgs,
position, 2 kg brown sugar.
2 kgs of brown sugar was recovered from the joint possession of this petitioner and another accused
Another.
person. Stop. There are only 7 witnesses named in the charge sheet. Stop.
My
The
lord, 12
he said 7,
is 12. First charge sheet that
12. Stop. The trial may be concluded on an early date. Paragraph. We find that the first charge sheet was filed on April 2024. Stop. However, with that charge sheet, the FSL report was not filed. Stop. The FSL report was filed with the supplementary charge sheet on
31st of May.
May 31, 2024, i.e. much beyond 180 days from the date of arrest of the petitioner. Stop. According to the division bench decisions of this court, the petitioner became entitled to statutory bail upon expiry of 180 days, since the charge sheet without FSL report is of no value. Stop. Paragraph. Hence, we grant bail to the petitioner. Accordingly,
Deeply of like.
Can we include some stringent condition that?
usual conditions are there. Yes. If you, after reading the order, if you want further condition, come and mention.
Praying for a day after.
Item number 6. I'm for the petitioner, my lord. My lord, this is my renewal bail application. My bail application lastly rejected on 25th of July.
What was seized?
2024. My lord, I am coming this condition. My lord, in my paragraph number 8,
We have asked you a question. Tell us.
Lordship, you will find that they showed 50 bottles of fancy deal recovered from the possession of this petitioner and another. But in the charge sheet, they have supplied a FSL report which shows the I am reading it out. The samples contain heroin. How fancy deal converted into heroin?
Seizure list says what?
Fancy deal. 50 bottles of fancy deal.
Yes.
And charge sheet shows that the samples contain
and
heroin.
FSL report says heroin.
Heroin. And another thing, my lord. Page 47. But in the charge sheet, they have showed that there is cocaine. We didn't get the FSL report because it was not lying in the case record. 47.
Oh, with the charge sheet, the FSL report was not filed.
It is filed, my lord.
With the charge sheet.
Yes,
Within 180 days.
within 93 days.
Within 180 days.
Yes. Yes, my lord.
Urine phosphate.
My lord,
Quite consistent with the fancy deal.
My lord, actually, I did not get the FSL report in the case record lying in the lower court.
Charge sheet বলছি নাকি বলেছে? Charge sheet দেখো। এটা তো FSL report. Charge sheet is 51. No, 51 is the fancy deal.
Hence, my lord,
Absolutely all right. No
my lord,
contradiction.
actually, we find that in the charge sheet of my application page number 17, I have seen that the samples contain heroin. It was shown. Maybe there is typographical mistake. Typographical mistake may be there.
No problem.
My
Will
lord,
you-
present petitioner is in custody since 350 days. Till today, charge is not framed. And after submission of charge sheet, 11 dates were passed. But till today, charge is not framed. and hence, I think there is a clear violation of Rule 14 of the NDPS rule of the expeditious test. My lord, I am.
No, that is not, we have seen that. Justice Bhattacharya's order, you're showing us.
No, my lord, I am showing the rule, my lord.
We have seen yesterday, we saw the rule.
Yes.
Don't worry. That's only for expedition, that is directory, not mandatory according to us.
My lord, next date
But
is.
no progress, sir.
Yesterday was the last date fixed.
Last 11 dates, what happened?
The date was fixed for.
Then
The charge receipt.
charge sheet was filed when?
29th of February 2024.
After that, nothing has happened. 15 charge sheet named witnesses. Almost a year in custody.
There was a direction, to conclude the trial in 6 months. So after that, 3 months has been lapsed.
4 dates also lapsed.
Yesterday was fixed for filling of charge. That has not been done.
এই তো তোমার রিজেকশনের সময় আগে কত কথা পেজ 18 রিজেকশনের সময়
After last rejection, my lord, 4 dates already passed. And I think that within the 6 month.
সঞ্জয় সিংহ
Yes, my lord.
on 25th July your prayer was rejected.
Rejected.
That
And-
order records that you are in custody for 399 days on that date.
No, my lord, there is maybe typographical mistake.
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 You are in custody for
350 days.
350.
350 days.
almost a year.
Almost a year, my lord. Till today charge is not paid after the last rejection also.
যেহেতু 6 মাস দিয়েছে 6 মাসের পর আসি নাকি না হলে ফিরে উঠতে পারি
And already next date is fixed on 22nd of November. My lord, it is 5th date. after
sole
that,
accused
2 accused. 2 accused.
joint position
Joint position.
next date is fixed on
20th of November 2024.
let us post it after that then.
My lord, then. There is no progress, my lord.
3 months is late.
Near about 4 months is running, my lord.
We'll grant him interim bail.
Next date, charge sheet.
Do whatever you like, you have not done anything till now.
3 months is late.
How can you
15
conclude it
witnesses,
within three
but we are
months?
babies, we don't know. The petitioner renews his prayer for bail, which was rejected earlier on July 25, 2024 in CRM bracket NDPS 278 of 2024. Stop. While rejecting his prayer, a coordinate bench had directed that the parties shall make all endeavors to ensure that the trial is concluded within 6 months from that date. Stop. Paragraph. The petitioner says that there has been absolutely no progress after that order was passed. Stop. In fact, after filing of charge sheet on
Charge sheet on 29th of February.
February 29, 2024, nothing has progressed. Stop. Even charge has not been framed. Stop. 11 dates you said.
11 dates after filing of charge sheet.
11 dates were fixed after filing of charge sheet, but nothing happened. Stop. There are 15 charge sheet named witnesses. Stop. Trial has not yet begun. Stop. It is anybody's guess when the trial will conclude. Stop. He is in custody for
350 days.
350 days. Stop. On the touchstone of Article 21 of the Constitution, he prays for bail. Paragraph. Learned State Counsel, while opposing the prayer for bail, says that November 20, 2024, has been fixed as the date for consideration of charge. Stop. going by the earlier order dated July 25, 2024, still about 3 months' time is left for concluding the trial. Stop. Paragraph. We have considered the rival contentions of the parties. Stop. We do not see any possibility of the trial concluding within the next 3 months or on an early date, going by the conduct of the trial. Stop. The petitioner is in custody for close to 1 year. Stop. The paramount importance of a citizen's fundamental right to personal liberty and speedy trial as contemplated by Article 21 of the Constitution, cannot be lost sight of. Stop. Paragraph. Without touching, in view of the inordinate delay in progress of trial, we are of the view that the restrictions in Section 37 of the NDPS Act stand rebutted. Stop. Without touching the merits and purely on the ground of delay in progress of trial, we allow the petitioner's prayer for bail. We'll give it bail now. Accordingly, next.
Number 7, I'm praying for 2 days adjournment, your lordship. Wait,
Today's or 2 days?
2 days.
2 days. Thursday.
Allow for the petition. My service.
Foxo?
Yes, sir.
Hey, থামো, থামো।
304B with Foxo.
তুমি আলাদা করে করোনি প্রীতম?
10. I'm for the petitioner, Lordship. Lordship, I'm in custody since 220 days. Charge sheet already submitted and trial is in progress. My lord, I am praying for bail on same footing of co-accused Jalpaiguri and another is Sudipguri. I am for mother-in-law. Prime accused is also in custody.
Where's your,
Earlier officials, 430 already turned out, but. No, my lord, 430 never filed on 439.
you're renewing your prayer? But that was before this Jalpaiguri was
Yes.
granted bail.
Yes.
So if Jalpaiguri and this
Sudipguri.
Pinku Kuri stand on the same footing, that you don't dispute.
Lordship knows better than us that the main grievance against the mother-in-law, not father-in-law. In every cases,
Jalpaiguri Kuri is the father-in-law.
father-in-law,
And who is Sudip Kuri?
Brother-in-law.
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 But the present petitioner is a mother-in-law.
Yes, how long she is in custody?
120 days.
120 days. Yes, what are the allegations? Give the CD.
Lordship, earlier occasions, I have shown that in the postmortem report, there is others injuries also.
Is this the matter where the husband is specifically implicated
Yes. On yesterday.
and the others are general statements?
But all are demanding and
No, then this.
When your prayer was last rejected?
Last day rejected on
10/9/24. 10 September 2024.
Yes, 164 statement page 35.
Worships,
10 September.
10 September. No change of circumstances. That's why
No change of circumstance.
Sir,
You say trial is in progress.
progress, my trial, date was fixed for trial, but till now, no witness.
How many witnesses?
There is 14 witnesses.
40 minutes.
Come back after some time.
Yes,
It
Lord.
is
That was
10
mother-in-law.
September reject করেছে।
Your petitions are already turned out after considering
না না রিজেক্ট করে দাও দেখ না
mother-in-law. Yes, that's why.
আসুক না বলো যে প্রত্যেকদিন আসতে পারে হ্যাঁ এই এটা এসো we are rejecting. Do you want to press it?
My lord, I am not.
Not sorry.
Charge sheet not. How long are you in custody? Oh, anticipatory bail.
Yes. 15 years of marriage.
Yes.
Mother-in-law and husband.
How old is the mother-in-law?
If your lordship kindly consider the 161 statement of the neighbors, 3 neighbors,
Which page?
page 10, 11 and 13. Demanding more dowry and torture upon the deceased wife was
It is the neighbor statement.
yes, my lord.
10, 11.
Page 10, 11 and 13, my lord. She is compelled to take poison.
Yes, sir. Postmortem report page.
Yes, my lord. PM report is at page 29, 29. Death was due to the effect of poison, antemortem intention.
But kindly see the statement of the mother child.
15 years of marriage, my lord, child is our least responsibility.
It's a poison. We'll grant to the mother-in-law only, not the husband. Ishu. No, no.
Direct evidence against the mother.
Go surrender, try to obtain regular bail. Age, 74.
306 is there.
The petitioners pray for pre-arrest bail, stop. They say that they have been falsely implicated, stop. The petitioner number 1 is the mother-in-law of the victim lady who apparently committed suicide by consuming poison, stop. The petitioner number 2 is the husband of the victim lady, stop. Paragraph, the petitioners say that the victim lady and the petitioner number 2 were in marriage for about 15 years. Stop. There is no incriminating evidence against them. Stop. They are willing to cooperate with the investigating officer. Stop. Paragraph. Opposing the prayer for anticipatory bail, comma, learned state advocate draws our attention to the material in the case diary, including statements of neighbors. Stop. The witnesses clearly implicate the petitioners herein. Stop. Paragraph. Considering the age of the petitioner number 1, bracket 74 years, and that she's a lady, comma, we are inclined to grant anticipatory bail to her so long as she cooperates with the investigating authority fully. Stop. Paragraph, insofar as the petition number 2 is concerned, comma, we are not inclined to allow his prayer for anticipatory bail. Stop. Paragraph, the application is dismissed insofar as the petitioner number 2 is concerned and is allowed insofar as the petitioner number 1 is concerned. Accordingly,
I'm going to the lordship. Item number 16, I am for the state of lordship. Item number 17.
But I am for the. But offense under section 85, 117 subsection 2 and 109 of the BNS. But 198, 325, 307 of the IPC. But marriage was solemnized 10 years ago, my lord. Petitioner is the, my lord, the husband. But there is a case and counter case between the husband and wife. But we have lost the case on 11th, and subsequently they have lost the case on 14th. But I have the copy of, I have stated in my.
You have lost the case. What case?
Against
against your wife?
Yes, against my wife and my in-laws.
What case?
Kindly see.
Criminal case?
Yes.
Under what section?
Malad, it was Malad. Under section 127, 118, 118 subclass 2, 351, 3/5 of the BNS, my lord.
What are those?
Malad, previous had Malad 326, 305, 325. Malad.
Anyway, your bail, anticipatory bail was rejected by the session judge, although the other co-accused person's
Yes.
anticipatory bail was allowed.
Yes.
So whether this person stands in the same footing with regard to co-accused or not. Yes. Where are the injury report?
Yes, my lord. At page 18, my lord.
Kindly see page.
He was
paragraph.
assaulted with a lathi, and not only that, she was submerged with the water with the intention to kill.
Kindly see 4 and 5 of my application, when I came to the house of the my lord wife, my in-laws, my lord, at that time, I was assaulted by the family members of the my lord.
And CH charge sheet got filed with the.
It says no marks of abrasion or bruise seen.
As per the.
Medical.
Nature of injury is also not mentioned here.
If your lordship kindly consider page 15 and 17. With the red-headed ticket.
Charge sheet not filed.
No, ma'am. This is the case
Kindly
of
see
July
paragraph,
24.
kindly see paragraph 4 or
Very
4 and 5 of my
preliminary stage of
application, my lord.
Yes, what is the statement of this thing? The complainant?
If your lordship kindly. There is no statement of the.
And my lord, this is the counter case.
Counter case against whom?
Against my lord, family members of the my lord wife.
Which one was initiated earlier? This one or
This,
your?
Allah, I have initiated earlier, thereafter, against me, this case has been started. 11th of my lord, July incident was happened, thereafter. my lord.
Sir, medical is not supporting and they have lodged the first case. They'll cooperate, he'll cooperate. Issue.
No statement has been recorded.
No statement also recorded. The petitioner
Statement of mother, father and neighbor also.
is the husband of the victim lady. Stop. He says that he has been falsely implicated. Stop. He has filed a criminal case earlier in point of time against the victim lady and her family members. Stop. This complaint is a counterblast to that. Stop. He is prepared to cooperate with the investigating authority fully. Stop. He prays for anticipatory bail. Paragraph. Opposing the prayer, comma, learned state advocate draws our attention to the material in the case diary. Stop. Paragraph. We have seen the medical report. Stop. Prima facie, comma, the report does not support the prosecution case. Stop. There is also no statement of the victim lady. Also no statement of the victim lady
Victim lady herself will de facto.
appears to have been recorded either under section 160, এখন তো 161 হবে না, দেখে নিতে হবে. What is 161 in the new act?
182, my lord.
181.
182,
Either under section 182 or under section 1 and 164?
183.
183. Or under section 183 of the BNS, huh?
No, my lord.
There's a
CRPC to.
164 equivalent to 183 BN.
yes. And 161 is
182.
ঠিকই আছে. BNS, stop. Paragraph on an overall consideration. Anna, stop. The case of the petitioner that the present complaint is by way of a counterblast cannot be ruled out altogether. Paragraph on an overall consideration of the facts and circumstances of the case and the material on record. We are of the view that immediate custodial detention of the petitioner may not be necessary so long as he cooperates with the investigating officers.
For the petition. My lord, the case is initiated under section 85, that is old section 49A only. So for the allegation is concerned, the alleged marriage was took place on the 23rd June of 2024. After that, I did not provide proper food and other medication to the de facto complaint and usually committed torture upon her. And so far the allegation is concerned, I am an habitual drunkard and I took some snaps. So far the allegation is concerned after undressing her. This is the whole about the allegation. On last occasion, your lordship was pleased to ask that PP to
Oh,
furnish.
41A.
Oh,
Yes.
that is 41A notice was is served upon me or not. So far my instruction goes, no notice was served. That is nowadays 35(3).
Your Muhammad Faisal Ahmed.
Yes.
My lord.
Faisal Ahmad and as well as Muhammad Mansoor Ahmad was on the next page, on the 41 inquiry.
Just to make the case more serious, some story has been incorporated. There is no injury report with him.
এই এটা দেখি সিআরপিসি দেখি আরেকটু দাও। Comply with the notice, we are adjourning this matter. We are adjourning this
In
matter.
the meantime, my lord, my humble submission with your lordship and immunity may be not to arrest may be passed. Because if he is very much influential. If I went there, I will be arrested immediately.
Lordship, I am on behalf of the de facto complaint, Lordship, the petitioner threatening to my client, Lordship, to withdraw the case, Lordship. And
No. that
every
is-
time they
that-
calls me, Lordship, and WhatsApp message also, Lordship.
You should investigate the matter.
I
Lord,
have already lost the complaint, Lordship.
Friday
Another complaint.
Friday রাখো পরশু দিনও অ্যাপিয়ার করো আচ্ছা মানডে করো Mr. Subba, he'll respond to the notice by Friday. By Friday, we'll keep this matter on Monday. Don't do anything. Don't arrest till Monday. Till Monday. Read order dated November 4, 2024. যাক এটা 4th November করেছো তোমরা নাকি বেশিরভাগ অর্ডারই 4th October করেছো কালকে হ্যাঁ সন্দীপে 4-5টা বোঝো হ্যাঁ November 4, 2024 stop. Learned State Council has produced copy of the notice issued to the petitioner under section 41 capital A CRPC. Stop. Paragraph. The allegation is under section 85
of BNS.
of BNS Act, bracket lecho, corresponding to section 498 capital A IPC. Stop. Paragraph. List this matter once again on Monday date thou. Stop. In the meantime, the petitioner shall respond to the notice under section 41 capital A CRPC. Stop. And report to the concerned police station. Stop. Till the next date, comma, let the petitioner not be arrested.
Grateful.
No time for the petition.
Yes. Hey, let's eat it out. Hey. 19th state?
19 state.
No time for the petition.
1990.
State is not there, sir.
Kindly make it not.
20
20 state.
But offense under section 126 subclause 2, 180 subclause 2 and 109 of the BNS matter. 341, 326, 307 of the Indian Penal. Alert, actually the victim and the petitioner both have a shop in the same market. Both have a shop in the same market and some dispute has been cropped up between the parties. And what allegation is that the petitioner had entered into the shop of the victim and what started assaulting. That is the what allegation with a knife.
Serious allegations, severe injury on the neck, there was chance of death of this person. He could have died, my lord.
He is discharged from hospital.
He is discharged from hospital, the injury report is
How,
there.
how long was he there in
Page
hospital?
33. He was not quite for a long time. my lord.
Page 33.
33 is the injury report, severe injury. There are eyewitness page number 10 and 11.
But my instruction is that, my lord, the victim had an illicit relationship
Those are
with
all
the
stories.
wife of the petitioner. And that is my instruction.
Those are all cooked up stories, nothing like that. The attack was from backside.
Yes, where is the statement of the victim?
Page number 10 and 11. Statement is there. This is the statement of the witnesses, madam. 10, 11 eyewitnesses.
Yes, the statement of this Sujan victim.
It's my page number 8.
Page 8.
I think.
No, Sujan is not victim, but eyewitness. Sujan is the victim. Sujan's statement is victim statement.
Sujan's statement is not there. I think he is not in a position, madam, because there is an injury on the neck. That's what. Severe injury, madam.
The incident was happened on 10th of September 22.
Charge sheet not filed, madam. Sir, there was
Legal
any
statement was not recorded, madam.
Not this
Well,
one. No, issue.
Or kindly fixed it on madam.
The petitioner prays for pre-arrest bail. Stop. He says that he has been falsely implicated. Stop. He and the victim own shops in the same market. Stop. There was a dispute between them. Stop. Hence this false case. Paragraph, learned advocate for the state draws our attention to the material in the case diary. Stop. We have seen statements of witnesses recorded under 164. Section 161 CRPC. Stop. They clearly implicate the petitioner. Stop. We have seen the medical report and photographs from the case diary. Stop. The victim appears to have sustained severe injuries by reason of being attacked with knife. Stop. Paragraph, in view of the gravity of the allegations and the material incriminating, prima facie incriminating material. against the petitioner, comma, we are not inclined to allow his prayer. Dismissed.
Twenty-one Lordship, I am for the petitioner.
Oh,
Of the pretext of marriage. What's that?
After how many years this complaint is lodged? After 1.5 years.
Yes, Lordship. Lordship, may I? Denied marriage.
Yes?
He denied marriage after that, Lordship, the complaint was lodged.
Yes.
Lordship, this allegation is completely false, Lordship. Lordship, the fact is that they are the resident of the same locality.
Yes, this incident, you see, false promise took place prior to the coming of the new act. Under the new act, it is punishable.
Yes.
But under the old act, this law did not exist. And this incident took place 2 years ago.
2 years ago.
charge sheet filed?
Charge sheet,
No.
and nothing.
He'll cooperate, he'll cooperate.
I will
Issue.
cooperate, Master.
The petitioner says that he has been falsely implicated. Stop. There has been a long-standing amorous relationship between the petitioner and the victim girl. Stop. He is prepared to, he will cooperate with the investigating authority fully. Stop. He prays for a pre-arrest bail. Paragraph. Learned state advocate draws our attention to the material in the case diary. Stop. We have seen the statement of the victim girl recorded under section
164.
164.
164 of the CRPC and 183 of the BNS.
183 BNS. Stop. She admits of a love relationship between her and the petitioner. Stop. The allegation is that the petitioner had physical relationship with her by meeting out false promise of marrying her. Stop. Paragraph. We have seen the medical report. Stop. The same prima facie. Now, the same reveals nothing. Same reveals nothing. Stop. Paragraph on an overall consideration of the facts and circumstances of the case, comma, we are of the view, the complaint was lodged about 1.5 years after the date of alleged incident. On overall considered facts and circumstances and the material on record, comma, we are of the view that immediate custodial detention of the petitioner may not be necessary so long as he cooperates fully with the investigating officer. আচ্ছা এগুলো কন্ডিশনের ভেতর আরেকটা ওখানে রিপিট করে দেবে, will fully cooperate with the investigating officer. থাকে লেখা থাকে অ্যান্টি বেলেও থাকে। আচ্ছা, ঠিক আছে ঠিক আছে আছে।
Item number 22. For the state ballot. I'm holding the military ballot.
Allegation under section 341, 323, 325, 307, 302, 506, 34. Incident that they have been either there is the enmity and the principal accused, namely Anil Das, inflicted knife injury and there was a people.
Okay,
died.
302.
Yes, ma'am, 300.
Case of the brutal murder, one has been died, madam, and two injured, madam, brutally injured, madam.
He is named in the FIR, petitioner.
Yes, madam.
All the
Absolutely.
five, there are five accused person in the affair.
Yes.
And the brother, all the brother and father, all are implicated in the incident. Can you see the my role? All out of five, four other accused person arrested, and all are enlarged on bail. Charge sheet submitted. I am the brother. I am the FNO accused person.
My lord.
All the family members.
My lord, the case has been started on, my lord, January, my lord. So still he is absconding, but kindly consider the conduct of the present petitioner, my lord. And he is the prime accused.
Okay, what are the allegations against him? Yes, which page?
But I'm referring, my lord, kindly appreciate page 123 and 124, my lord. This is a 164 statement of the brother of the complaint.
123.
And yes, my lord, 1, 2, 3 and 1, 2, 4. This highly corroborated with the prosecution case, my lord.
1, 2, 3.
Yes, my lord. All the FIR name and offending weapon also recovered, my lord.
Who is Ashok Das?
Ashok Das is a brother, my lord,
And
of the present petitioner. Present petitioner Abhiram.
yes, but then this says that Ashok Das দা দিয়ে আঘাত করে তারপর তার বড়দাদা আর বাবা
Yes.
অনিল দাস আমায় ছুরি দিয়ে
Borda is Abhiram. Present petitioner.
বড়দা ইজ অভিরাম
Abhiram.
No, my lord. I am younger brother. No, my lord.
Name is all of the present.
Yes, but Abhiram is not here.
123 and 124, my lord. Yes, 124. And thereafter, my lord, page 90, page 122. The 164 statement is there, my lord.
Well,
These are the statement of injured person.
My lord, complaint, defect of complaint.
yes,
Brother of the defect of complaint. If the
Injured person.
Injured person doesn't name Abhiram.
uh,
Names Abhinash, Anil.
page 19, my lord,
Page 90. No, we are considering the 164.
164, all the 164.
Okay, page 90.
90.
Yes, this is statement of whom? Complainant.
This is the witness, independent witness. Father, along with the all these.
Yes, Anil Das is granted bail.
Yes, ma'am. All four other accused
This is the main question. Main allegation is there against this Anil Das. He is on bail.
Yes, ma'am. Granted.
No, his involvement is there, okay?
After language is custody, my lord.
Yes.
And this is the 438, my lord. That is the main.
No, right.
my lord.
Picture
My submission is, my lord, go and surrender to the trial court and obtain bail, my lord. All the surrender and they are obtained bail, my lord. From January is absconding and now I'm referring 438.
No, if you want to press it, we'll reject it. Go and surrender. What do you want to do? What do you want to do, Mr. Poddar? Go surrender if you are arrested, obtain regular bail.
My lord.
23.
Yes,
I have what state.
yes.
363, 328, 34 of the Indian Penal Code, well, victim are recovered, now staying with the parent when a charge is submitted. I am friend of her friend, madam. Female.
Okay, case of 2018,
No.
18.
2018 case.
Even absconding for 6 years.
Yes.
That is what they all say. That we didn't know.
Charge sheet submitted, madam.
Oh, right.
I mean, our classmate, madam, all this is in.
Petitioner is a lady.
Yes, madam.
Yes, give the case diary.
Your Honor, just having a bird's eye on the 164 statement,
Yes.
it will be clear that this petitioner offered a beetle to the victim, and after taking the beetle, she rather became unconscious, and on that stage, she had been eloped by the other accused petitioners. This is the case. So section 328 has been inserted.
She was recovered after how long?
Place of recovery?
Recovery memo, house of the de facto complainant.
House of the?
De facto complainant.
The victim is recovered from the house
House
of
of the de
defendant.
facto complainant.
That means not recovered from the place of any of the accused person.
No. But after offering the beetle, when she took the beetle, that means some spurious or some poison was administered.
Any medical examination done?
No. Page 11 is the recovery memo.
Yes, page 11.
11 is the recovery memo. And she was recovered after 1 month.
So from where did the complainant get the victim girl? How did the victim girl come from to the house of the complainant?
What is your age?
My age is 20.
And the victim is of only 16 years. And after 6 years.
Sir, you filed your charge sheet.
Yes, we have filed the charge sheet. But
Anyway, if you want to further investigate into the matter, she'll cooperate with you. She'll cooperate with you. ভেতরে তো নেই anyway. The petitioner says that she has been falsely implicated. Stop. She has no role to play in the abduction of the victim girl. Stop. The girl has been recovered. Stop. She was not aware of this case having been filed against her. Stop. That is why she did not report to the police. Stop. She is fully prepared to cooperate with the investigating authority. Paragraph. Learned advocate for the state says that draws our attention to the material in the case diary. Stop. He says that the petitioner
Lordship, one indigent. She was taken to in Assam.
The petitioner administered poisoned. Petitioner caused the victim to consume poisoned betel nut. Stop, which made her unconscious. Stop. Thereafter, toxic poison nut toxic. Thereafter, she was taken to Assam. Stop. However, she was recovered from the house of the de facto complainant. Stop. Paragraph. On an overall consideration of the facts and circumstances of the case, and the fact that the petitioner is a lady, young lady, aged about 20 years. Stop. We are of the view that immediate custodial detention of the petitioner may not be necessary so long as she cooperates with further investigation, comma, if any. If any.
Much obliged.
Report to the police station within 7 days. ওটা দেখো, এটা বলে দাও চার্জশিট has already been filed. ঢুকিয়ে দেবে। হ্যাঁ, আরেকটু দেখো। দেখো।
Item number 24.
I'm for the petitioner, my lord. Against, allegation against me is rash driving, my lord. As a result, my lord, rash and negligent driving. And as a result, my lord, this one person get occurred.
One person was killed.
Died, my lord. And this allegation case was started under section 181, 125B and 106 of 6 and subsection 2 of BNS Act, my lord. Previously, my lord, 279, 337 and 304, my lord. And in this offense, my lord, regarding 106 of BNS Act 2, my lord, there's notification that it is yet to be enforced, my lord. And I'm a 24 years boy, my lord, and there's no antecedent and this kind of case against me pending in any court of law, my lord. I shall cooperate with the investigation agency, my lord. I shall not temper, my lord. At any terms and condition, my lord, may I be given bail, my lord.
162 has not come into force.
Lorships, the new act, Lorships, whoever caused death of any person by rash and negligent driving of vehicle not amount to be culpable homicide and escaped without reporting into the police officer or magistrate soon after the incident shall be punished with imprisonment for either disclosure for a term which may extend to 10 years and shall also be liable to fine, your lordship.
Which section is this?
Lordship 106 clause.
106.
Yes, your lordship.
106 clause 2, as per the notification of 23rd February, has not come into force.
Yes, your lordship.
Then how can there be an offense under this?
Due to-
What is the date of the incident?
24th August 2024, this year only, my lord.
And what is 281 of BNS?
280 and 279.
279.
Cause
Title says 281.
Yeah, previous to.
Previous 279.
Oh, previous 279.
And all are tribal by the magistrate, my lord.
Do you want to find out whether subsequently it has been brought into force?
Yes, your lordship.
No, my lord, yet to be. Yet to be enforced.
Yet to be.
My lord.
Lordship, but there are some stringent condition
Yes,
imposed.
yes.
Grateful.
Yes, yes. The petitioner prays for pre-arrest bail. Stop. The allegation is of causing death by rash and negligent driving. Stop. Section 106 bracket 2 of the BNS Act. BNS Act to know what? BNS, comma 2024. How bulwal 23 has been invoked. Stop. The petitioner says that section 106 bracket 2 has not been brought into force. Stop. He produces copy of a notification dated
February 2020.
February 23, 2024, whereby the Ministry of Home Affairs appointed July 1, 2024, তারপরে quote করো, as the date on which the provisions of the said Sanhita, comma, except the provisions of entry relating to section 106 bracket 2 of the Bharatiya Nyaya Samhita, 2023, comma, in the first schedule, comma, shall come into force. Stop, unquote. Paragraph, learned State advocate draws our attention to the material in the case diary. Stop. He leaves the matter to the discretion of the court. Paragraph. Since section 106 bracket 2 of the BNS, 2023, has not yet come into force, no charge would lie under that section. Stop. Paragraph. Considering the facts and circumstances of the case, charge sheet filed.
No, my lord, very initial stage.
We are of the view that immediate custodial detention of the petitioner may not be necessary so long as he fully cooperates with the investigating officer. Accordingly, in the event of arrest.
Proceed meet the items.
Yes, yes, that is always there. Fortnight, once in a fortnight. We'll come back.
My lord, 25, I am appealing for the petitioner, my lord. My lord, the dispute between two brothers and their respective families in respect of the landed property. Case and the counter case, my lord. The petition, the allegations against the petitioner under section 447, 427, 325, 326, and 354, 504 of the Indian Penal Code. My lord, I have also suffered injury. I have annexed the injury report in my petition.
Whose
My lord,
case is the prior case?
my lord, prior case, my lord, both the cases, my lord, at the same time, their case has been registered, my case has not been registered. My lord, and the principal accused, he has already granted bail, my lord.
Charge sheet?
Charge sheet not filed.
Not filed.
Who accused on bail?
The principal accused on bail. my lord.
The petitioners say that the present complaint is the outcome of a dispute relating to landed property. Stop. There is case and counter case. Stop. The petitioners have also sustained injury. Stop. The petitioners will fully cooperate with the investigating officer. Stop. They pray for anticipatory bail. Paragraph opposing the prayer, learned state counsel draws our attention to the material in the case diary. Stop. He says that investigation is going on and charge sheet is yet to be filed. Stop. Paragraph. We have seen the medical report. Stop. No serious injury appears to have been sustained by the victims. One victim or many? One.
One week.
By the victim. Stop. Dispute arising from landed property, dispute relating to landed property cannot be ruled out. Paragraph on an overall consideration of the facts and circumstances of the case and the nature and gravity of the alleged offense. We are of the view that the petitioners, one of petitioners need not be arrested immediately so long as they cooperate with the investigating officer. Report করবে খালি petitioner number 3 ছাড়া, হ্যাঁ? ও as and when called for. কারণ মহিলা।
Grateful, Your Lordship. The 26th, Your Lordship, kindly take it up tomorrow, Lordship.
Not
Grateful.
today.
And for the petitions. This is a complaint, criminal complaint pertaining to an agreement of sale. That agreement, this is the FIR, last 2 pages is the agreement and the FIR. The state, that paragraph 2, that accordingly on 1/12/18, an agreement of sale, in the last 2 paragraphs of the FIR. That
Yes,
is there
which page?
in the last 2 pages, certified copy. Last 2 pages, certified copy, FIR.
Yes.
Which paragraph of the FIR?
Para 2.
Para 2.
That accordingly on 1/12/18, an agreement of sale was executed in between myself and said Anu Norden, being the constituted attorney of his daughters, Ms. Pratiksha and Ms. Pratika Norden. And on the date of execution of the said agreement, I had paid a total sum of ₹6,50,000 only an advance to Sri Bhanu Norden. This went on. The dispute went on. It was executed in 18, and this gentleman came forward to lodge a complaint without filing any civil case, without giving any notice of specific purpose. He straightway went to the police station. And in the meantime, 2018.
My learned senior friend goes further, my lord, I will be praying that 1 day's accommodation to show your lordship some documents. Only 1 day.
What document will you show? 42406 case?
No, my lord, there are some
Milord,
conversations.
This is
My lord, there are certain
Property
conversations.
Property dispute.
My lord, there are certain.
civil dispute.
My lord, there were certain.
Oh, you have not received the case diary?
No, no, I have been
No.
for the state.
I am
He
for
is
the
appearing for the.
Come back tomorrow, come back tomorrow. We can't, day after tomorrow, Thursday.
Yeah. Great.
নেই আছে 28
Yes, madam, 20. Section 85 and 103, madam, section related to 498, 103 means, madam, 302. Madam, it will be, madam, this is committed suicide, madam. Not 302 attract, madam. All are in-law, madam. Father-in-law, mother-in-law, marriage sister-in-law, and husband of the marriage sister-in-law. Husband in custody, madam.
103 is 302.
Madam, earlier 302, my instruction, she committed suicide. 302, not that, madam. Maybe 304.
Let us see the PM.
Case instituted under 302.
But in this case, the allegations regarding the Sasur, Sasuri and Jawai are same. So the
Sridhar is who?
husband is not only the principal accused.
Husband arrested and-
164 statements.
Husband arrested now in custody.
Yes, this is 164.
164 is there, clearly detailed, the Sasur, Sasuri and.
After how many days of marriage? After how many years?
After 3 years, madam. 3 to 4 years.
Within 7 years.
All are.
And the statement of the neighbors are also there, page 14. CS has been submitted on 16th of October. Only against Shantanu Adhikari, 85, the BNS, the abatement is there. Otherwise, petition number 1 and 2, there is a direct allegation.
This is the neighbor's statement.
This is the statement, yes, my lord, statement 161.
Yes, 164.
164, this is 161 of.
Yes, 84 and the other is 83.
Page 14, my lord.
What is the age of Promila?
And the new section 82 that is added for the dowry bill that has been added.
Yes, any other statement? This is the neighbor statement.
Page 14,
Page
the
14.
161.
Page 14.
That is also a eyewitness.
Formula will be around 50 years. Like,
Then it is the father-in-law. And the mother-in-law.
Postmortem report.
He was ousted from the house.
This petitioner number 3 resides in the same house.
Oh, marriage.
Only abatement.
Only abatement.
Husband arrested, my lord.
Yes,
husband arrested.
father-in-law, which father-in-law?
Petition number 1.
Husband
Petitioner
arrested,
number 1 is the father-in-law.
Petition number 2 is the mother-in-law.
Who is the mother-in-law?
my lord.
3 is
He committed
sister-in-law.
suicide. There is no suicide note at all, my lord.
Sister-in-law.
It is
only
a arrest of
abatement.
general and omnibus, my lord.
Suicide note.
No,
There is
page
no
number,
suicide.
just a minute, page number 14 is the allegations against the father-in-law. No, page 14.
14, yeah. Father-in-law. That she was
Only
ousted
father-in-law.
from the house. And 164, father-in-law and mother-in-law and husband.
Yes, 164 is 83.
Page number 84.
84.
Charge sheet file.
Charge sheet
Just
filed.
filed.
Now husband is also in custody, my lord. They are all other family
They
members.
are absconding for a long time.
Long time, my lord. Training before court, my lord.
Eighty-five is the victim's father.
My lord. And 84 is an independent victim. For their respondents, his charge sheet is not filed, my lord, the category the husband will get the bill. That's why charge sheet has been filed.
Charge sheet submitted nature of allegation general and omnibus. My lord. In case of 490 and this type of allegation.
Incident of
Incident of 20 July 2024.
July 24.
And husband suffering custody also, my lord.
Yes. We are not allowing the father-in-laws. No, the other two we let go.
Yes, sir.
The petitioner number 1 is the father-in-law, comma. The petitioner number 2 is the mother-in-law, and the petitioner number 3 is the sister-in-law of the victim lady, who appears to have victim lady. Stop. The 85 is
490.
498A, and 103(1) is 302. The allegation is of murder and torture and murder. Stop. Paragraph, the petitioners say that they have been falsely implicated. Stop. The husband of the victim lady who died, comma, is in custody. Stop. The allegation against the petition number 3 is only of abatement. Stop. They pray for anticipatory bail. Stop. They say that they will fully cooperate with the investigating officer. Paragraph, opposing the prayer, comma, learned state advocate draws our attention to statements of witnesses recorded under section 164 as well as 161 CRPC. Stop. There are allegations against all the petitioners, against the petitioners generally, and also specifically against the petitioner number 1. Stop. Paragraph. On an overall consideration of the facts and circumstances of the case, comma, we are not inclined, and given the gravity of the alleged offense, comma, we are not inclined to allow the prayer of the petitioner number 1. Stop. The application is dismissed as regards the petitioner number 1. Paragraph, however, comma, considering that the petitioner number the allegation against the petitioner number 3 is only of abatement, and the petitioner number 2 is also how old is he? She is a 50-year-old lady, comma. We are of the view that immediate custodial detention of the custodial interrogation of the said petitioners may not be necessary so long as they cooperate with further investigation, comma, if any. রিপোর্ট থাকবে না, এটা রিপোর্ট করতে বলো না মহিলা তো।
But I have for the petition. 185 and 107 subclause 2 and 109 of the BNS, and Marat earlier Marat 498A, 325, 307 of the IPC.
103 subclause 2 is what?
Marat 117 subclause 2.
Oh, 17
325.
325. And 109?
Is 307.
307.
Yes. And Marat 85 is a 498A. But petition is the husband, Marat, and other 3, Marat, accused person, co-accused person granted anticipatory bail by the learned session judge. I have annexed the order. Kindly see page 10 of my application. And Marat, there is no injury, Marat. In the said order sheet, it is declared that there is a injury report is there, but no injury is there, Marat, specified.
Yes, Mr. Chakraborty.
As
She was admitted for 2 days, my lord. Injury report is here.
Marat, as per the FIR, he had sustained injury on her nose. As per the.
There's a fracture of a left orbital rope and confusion in the left.
Who took her to hospital?
What the neighbors?
Yes, a statement of the victim. Which page? Page 8.
Photos are also there, pictures of her injury.
Not page 8. Page 8 is, I think.
Just a check. It is necklace.
Charge sheet filed.
Charge sheet not filed.
On other three accused person granted anticipatory by the landed session judge.
You know. Yeah. You know. You go, we are not allowing this. We are not allowing this. You want to press it?
Then not.
Item 30, my lord, case diary is not available, my lord, can you make it not today? And 31, 32 also. my lord.
Who are the petitioners in 31, 32?
30 I am putting.
31, not today, 32? Sorry?
1 week adjournment.
32? 1 week? 1 week like Tuesday.
Tuesday or Monday?
Monday.
My lord, 33 also. 33 also.
Monday.
34.
Lordship, in this matter, Dr. Chaudhary is appearing and praying for 1 day's accommodation. On behalf of
35. 35.
For the statement.
36.
I put the petition, my lord.
36?
Yes, your lord.
36 state?
My lord,
35.
35 petitioner was not there.
36 was dispute, civil dispute will have co-accord granted bail, my lord, by the You are praying not to do.
37?
37.
Praying not to.
46 paying for not. 47.
47, my lord, this is the cancellation of bail, my lord. First time happening, let me allow to serve the court.
Let service of this application for cancellation of bail be effected on the respondents and affidavit of service be filed on the next date. How long? Next circuit? Paragraph. List this matter before the next available circuit bench. Yes.
But this is a relaxation of anticipatory bill, item number 48. 48. Marat, order was passed on Marat, 1st of February 2024. Condition is that Marat, the petitioner shall meet the investigating officer once in a week until Marat, filing of FF. Marat, from Marat 2000 Marat, from February Marat 2024, but I am complying the order Marat.
Yes, he has been complying.
Marat, I have annexed the Marat, the Hajira Khata in my petition Marat, kindly see. Yeah, yeah. All right. I have annexed the Hajira Khatas.
Since.
অর্ডারটা হয়তো তোমার ফেব্রুয়ারি থেকে দিচ্ছে।
11.
What is FF?
But perhaps my final form, charge sheet.
Charge sheet, final report.
Final form.
Final form.
Reporting final.
Is what do you say? He has been complying with it? Huh. Charge sheet has been filed now, charge sheet. The pending.
But I have no instruction about the charge sheet. Rarely submit. Charge sheet, either charge sheet submitting.
Then because this says until filing of charge sheet.
But my
Prayer is that, my lord, from last 6 months, more than 6 months, I am complying the, my lord.
How many days you have to appear? How many days?
Once
Take
a,
instruction.
once a week until.
Take instruction. Huh? We'll make it once in 2 weeks.
No, once a month.
Once a month. Very well. Sure. The petitioner prays for relaxation of one of the conditions of anticipatory bail that was granted to him on February 1, 2024 in CRM bracket A 120 of 2024, by a coordinate bench. Paragraph. One of the conditions was that he will appear before the investigating officer once in a week on the day and time fixed by the officer for the purpose of investigation till submission of FF, capital F, capital F. Stop. The petitioner says that he has been scrupulously complying with that condition since February 2024. Stop. The same may be relaxed and he may be permitted to report to the investigating officer once in a month till the submission of charge sheet. Paragraph. Learned advocate for the state in his usual fairness, on instruction, says that the petitioner has been complying with the conditions of anticipatory bail. Paragraph. In view of the above and in view of the fact that investigation must have progressed substantially by now, we allow the prayer of the petitioner. Stop. The petitioner may report to the investigating officer once in a month.
I'm grateful.
Disposed of, the other portions remain unaltered.
Charge sheet টা হয়েছে কিনা খবর নেই।
How about the state?
Relaxation.
Relaxation. There are 4 accused persons convicted and suspension of sentence, my lord. Bail was granted on 15 September 2020.
23.
23. There is a condition by the Honorable High Court not to leave the jurisdiction of the trial court. And suspension of sentence was allowed, bail was granted. And in respect to one of the applicant, the applicant number 2, named Jiban Gautam, his employment in Indian Army, and he want to join his service, there is a condition not to leave the jurisdiction. If the paper is not prepared, there is no possibility of early hearing of the appeal,
Appeal of which year?
Appeal of 2023, but I was in service, and I only in respect to one person, I want to modify this condition.
This is the petitioner's name is what?
Leave may be granted to amend the cost title. The appellant number 2, named Jiban Gautam. I am accepted.
But you have written Basant Rai.
Leave may be granted to amend the cost title. Appellant number 2, Jiban Gautam.
So applicant is Jiban Gautam.
Yes, madam.
Initially in the CRAN you had typed Jiban Gautam.
Yes, madam.
There is
I amend the cost title.
very well. That's all. You want to take instruction or what?
Yes.
We'll allow.
They were actually on the part of the trial. They were on bail.
Part of the
Oh.
service,
What is the charge?
Charge NDPS Act.
NDPS.
Order by the page 13 and 14 is the order by the Honorable Court. Only not to leave the territorial jurisdiction of the trial during pendency of the appeal. I want to.
Yes, sure. The appellant number 2, namely Jiban Gautam, leave is granted to correct the cost title. The appellant number 2, namely Jiban Gautam, has taken out the present application for relaxation of a condition of bail that was granted to the appellants on September 15, 2023. Stop. One of the paragraphs, one of the conditions of bail was that the appellants shall not leave the territorial jurisdiction of the trial court during the pendency of the appeal. The applicant says that he is employed in the Indian Army. Where is your place of?
Now at my lord. Earlier, my lord, Allahabad, my lord, now Udhampur, Jammu and Kashmir, my lord. Now
Udham,
posted.
Udhampur.
UDHMPUR, Udhampur, Jammu and Kashmir.
Now his place of work would be at Jammu and Kashmir. Stop. He may be allowed to leave the territorial jurisdiction of the trial court to report to work in Jammu and Kashmir. Paragraph. The learned advocate for the state tells us that the appellants were on bail during the trial.
After bail, your service continue.
After bail, during the trial, stop. The appellants never abused the liberty of bail or jumped any of the conditions. Stop. Paragraph, considering the facts and circumstances of the case, comma, we are inclined to allow the applicant's prayer. Stop. He may report to work in the Indian Army in Jammu and Kashmir. Stop. However, comma, as and when the learned trial court requires his presence, comma, he must be present in court.
He cannot be caught with ganja.
Please, Fulvio.
Effective.
नहीं क्यों?
Effective. Effective.
देखी डिफेक्ट है की देखी हैं?
এমন করতে হবে
वो है बाबा ये लगी
immediately করে করতে হবে কি রিএলএসএ নাকি এসএলএসএ প্যানে নেই
না বেঞ্চি পয়েন্ট করবে না না রিয়েল থেকে পাঠিয়ে দেবো
এখন থাকে
লিগাল সার্ভিস কি বলি বেটার
হাইকোর্ট লিগাল সার্ভিস কমিটি
এই আমার সাথে জানি না কখন সামনে
কোথায় বস হাইকোর্ট লিগাল সার্ভিস কমিটি কোথায় তাহলে রেজিস্ট্রারের কাছে কপি অফ দ্য অর্ডার পাঠাতে হবে ফর অ্যাপয়েন্টমেন্ট and let the matter be appear in the next submit for report.
আমাদের কাছেও বপরে রাখতে পারে ওটিপি রেগুলেটিং এর একটা বলছি নেক্সট
Next ঠিক আছে
This matter has come up for admission. This criminal appeal has come up for admission. Stop. This is a jail appeal. Stop. Paragraph. Learned registrar, comma, circuit bench at Jalpaiguri, comma, Calcutta High Court is requested to take necessary steps for appointment of a learned advocate to represent the appellant, comma, at the earliest. Stop. Let a copy of this order be sent immediately to the learned registrar, comma, circuit bench, comma, Calcutta, circuit bench at Jalpaiguri, comma, Calcutta High Court, for necessary action. List the matter once again, সামনের সপ্তাহে বুধবারে দিয়ে দাও। হ্যাঁ। Yes,
My lord, I am for the petitioner.
restoration, have you served?
My lord, the restoration has not been served because of the on the date of hearing, on the admission hearing, the learned advocate was not present.
Oh, admission stage, it was dismissed.
Exactly.
Admission.
there is no caveat
No cabinet.
দাও।
And then learned advocate was not appeared. 51. My lord has been pleased to dismiss the case. 51, 52.
52.
Lordship.
Appeal against?
Appeal, the matrimonial suit has been dismissed. I am the husband against the dismissal.
Oh, twice, thrice, nobody appeared.
Lordship, the advocate is not here. That's it.
Hey, sure.
Yeah, but my lord.
Against circuit. ওই তো, আমার আগের circuit. This is an application for restoration of FAT 14 of 2021, which was dismissed for default on July 6, 2023. Stop. The appeal was dismissed at the stage of admission since nobody appeared for the appellant on several occasions. Paragraph. We have heard learned counsel for the party, for the petitioner oblique appellant. Stop. We are satisfied with the explanation furnished for absence of learned advocate for the appellant on the day the matter was dismissed for default. Paragraph. Accordingly, the order dated July 6, 2023 is recalled. Stop. FAT 14 of 2021 is restored to its original file and number. Stop. Can is disposed of. Paragraph lists the appeal under the heading
Admission.
admission on Friday date to the other.
A defective the key.
55 and from next circuit.
No, why it is defective? 55?
Section 5.
Section 5, next circuit. Now, why the liberty the next circuit? Learned advocate for the petitioner says that an application for condonation of delay needs to be filed. Stop. He prays for the matter to be adjourned till the next circuit. Paragraph. Let that be done.
Fifty-seven, your lordship, I appear for the appellants. I was humbly praying the matter could be fixed for 13th, your lordship.
58.
57.
Why 13 is normally unlucky for people?
Your lordship, Mr. Idulji is appearing in this matter. He'll come physically, your lordship.
He'll come physically.
Your lordship.
Very well.
Much
On the prayer made on behalf of the appellant, let this matter stand adjourned and be listed again on 13 tarikh kore daw.
Much obliged.
Lordship, a day accommodation is seeking.
Sorry?
I'm seeking a day accommodation.
Not today.
59. My appeal. 56. Sorry, 60.
60. Defective টা কি চাই? Defective.
60. Defective. এই কি defect আছে দেখো 60 তে? তো ডিলে আছে না থাকলে আর কি কাকে অর্ডার দিতে বলতে তুমি একটা কাজ করো না কালকে টু বি মেনশন করে দাও দেখে যদি আসি টু বি মেনশন ডিরেকশন যদি নেক্সট সার্কিট করে দেবো কালকে টু বি মেনশন
61. 62.
61, 62 and 63 are similar matters. Your lordship will kindly grant a short pass over the conducting advocate is just on. Sorry,
Okay, 2 p.m.
No, the conducting advocate is just. I informed me, so he was not here, that's why.
You're for whom? The appellant is not there. Union of India is not there.
The honorable single judge in all these three matters have directed reinstatement. The dismissal and termination was held to be absolutely illegal. He holds the procedure.
Sir, the other side, the appellant is not present
I
today.
understand that the tendency of this appeal, Millard, my reinstatement has been kept on hold. Other employees who had terminated on similar grounds have been reinstated. Because they have not preferred.
Anyway, intimate the other side advocate will take it up if possible.
Yes, we will.
From tomorrow, if any party is not represented, we'll proceed ex parte.
Great.
Today also we are lenient. Second day of the circuit. Yes. Sorry?
DSG will appear in this case.
Deputy
Oh, I see, Mr.
Will be
Mujumdar.
available at 2 p.m. We can take it up.
Yes, madam.
Well, at 2 p.m. I have a fixed matter at courtroom number 2. Can we take it up tomorrow?
Not today.
64. I'm sorry, Millard.
Tomorrow civil matters will be in the first half.
64, I'm.
64, yes.
But other side not here.
Yes, you are for appellant.
I'm for appellant, my lord.
No, what happened, don't say, because you have appeared, the other side has disappeared.
Vanished. I'm also doing the same thing. Yesterday I cannot come because I started.
Mr. Rai, who is appearing for the other side? For the state?
Last occasion, the 2 persons.
Talk to him, ask him to be here tomorrow. We can take it up tomorrow then. Tomorrow in the first half, we'll take up these matters.
I just.
Find out, not today. We don't want to proceed ex parte
No,
today.
I also know.
From tomorrow,
No,
we'll.
that you also know that I also. Well, I may not be there.
From tomorrow, we'll be stricter.
You lost it. Never be the sick. I know it very well. I know both of you. 66. 67. 69.
67 and 68, Millard. These are, Millard, appeals arising from the same order. Millard, it's a matrimonial dispute. Millard, during.
Are you appearing?
Mr. Govinda Chandra.
So what application is this?
Millard, if I may just, Millard, allow
Yes,
me
yes.
1 minute, Millard. The decree which was passed.
Yes.
In that decree, Millard, there was one observation that the wife shall continue to enjoy a portion of the property despite dissolution of marriage.
Who was the plaintiff?
Millard, the husband.
Husband.
Now, Millard, both the husband and
Decree of
wife.
divorce passed.
Yes, Millard, both the husband and wife preferred appeals. Husband was agreed by that observation. That wife she will continue to occupy a portion of the property which is admittedly a joint property of the husband.
And wife is agreed, why?
By the dissolution of marriage. She says that the grounds as pleaded has not been made out on perusal of the evidence. Now, Millard, on the last, during the last circuit, Millard, we made an attempt to reconcile it. There was a certain proposals from the husband which was not agreed by the wife. We are close to a settlement. Millard, my respectful submission subject to your lordship's approval. Millard, if a special officer is appointed who will sit with the husband and wife and work out the settlement.
Why special officer? Go for mediation.
Millard, it was already referred to mediation once. and
Mediation
that was-
failed.
It failed.
How will special officer do this?
Any of senior members present here, Millard, he can sit with both of them. and the
Mediation
settlement.
failed before the mediator.
It has failed. At that point of time, probably they were also not in the state of mind to mediate.
Your wife or husband?
I am for the husband.
You're for the husband. You are for? What do you say?
Mr. Govinda Chandra, I appearing for this.
You are not appearing.
I am the junior.
Yeah.
He is out of station. But there's no time.
No, if both of you agree to resume your conjugal life, the matter can be resolved.
Millard, it won't, it cannot be resumed, but there is a settlement which can be worked out. The
They
husband,
are against, the wife is against the divorce.
yes, but now she is agreeable to a settlement.
Sir, if the two parties cannot settle between themselves, no special officer, no receiver, no mediator can help. You agree on somebody, we request him to act as Conciliator.
Millard, I can, since both the parties are from Kalimpong, Millard, I can propose Millard, if Mr. Roy agrees, Millard, he's a senior member.
Mr. Roy.
One or two sittings, Millard, it will be sorted out.
Do some good work. Do some good work. Some brownie points will be credited to your account. Yes, shall we do so? Shall we do so?
I take stacks of my, I think tomorrow.
Tomorrow, to be mentioned. We take it that you will have agreed, Mr. Roy. Try to sit with them.
We were very close to reaching a settlement during the last circuit. That's
Very
what we
well.
are
Tomorrow to be mentioned.
grateful. Millard.
69, I'm for the appeal in 69 lots, I'm for the opposite party. In conducting advocate routed, I'm paying for next week on Wednesday.
What application is this? 69?
No, this is not the application, now it's an appeal paper was ready.
So appeal has to be heard out.
Yes, ma'am.
This can 1 and can 3.
Those are all disposal.
Hey, you going to dispose of বলছি এগুলো আসছে কেন লিস্টে দেখে নাও দেখে নিয়ে কেটে দিও
No, I know that it's an appeal heading, but the paper is ready. Point is that my not.
No, will you be available for disposal of the appeal?
I'm praying for next week on Wednesday.
No, next week you will be available. That is the question.
on the prayer on the
train and flight.
on the request made on behalf of the
Respondent.
respondent এটা কত নম্বর
69 miles.
respondents comma let this matter stand adjourned and be listed again on 13.
Paper is ready. It is printed, submitted.
72. 73.
73, I appear for the appeal.
Yes, why defective? 73?
Milord, in the last circuit, the defect was perhaps cured, Milord. Since the Milord registry was of the opinion that we had not filed any limitation application, but it was later found out.
It was within
Later-
time.
It was later found out, Milord. They were under the impression that no can was filed for condemnation of the delay.
But later it was traced
Yes,
out.
Yes,
That's 5 has been allowed, section 5.
no, Milord.
So that has to be allowed first.
Yes, Milord. There are altogether 6 respondents. 4 have been served.
Oh,
But-
service is not complete then.
Yes, Milord.
Complete
However, Milord,
service.
the suit was for partition, so all the respondents happen to be family members.
Serve and come back when?
Milord, next week. Next week.
Learned advocate for the, it is 73. Appellant says that service of the application for condonation of delay on all the respondents is not complete. Stop. Let service be completed and affidavit of service be filed in court on the next date. Paragraph list this matter once again next Tuesday করে দাও।
Lordship, item number 72, Lordship. I am extremely sorry, Lordship. Item number 72.
Yes.
I am for the respondent, Lordship.
Appellant is not here, don't worry.
Lordship. So, the matter will be.
Not today, not today.
Not today.
74, Lordship, I am for the appeal. Lordship,
Respondent?
I have already served, Lordship, there is only
That
one
you have
respondent.
served. You may have served the affidavit service. টা।
Only one respondent.
Why one copy, sir?
Approach, Lordship.
ফেরত দিয়ে দাও। Not today. Sir, you are addressing a division bench. Have follow some discipline, please.
So I had mentioned this matter in the morning. The bond is 25,000. I have put this order before the court below, and they are saying 25, 25, 50,000. So if there is a clarification in the order, then it will be helpful.
They key as your, give 2 copies. Two sureties of like amount.
Yes, but the court below is saying it is 12.
Bail bond has to be 50,000.
50,000.
Yeah. To be mentioned tomorrow. Who was for the state? Mr. Chakraborty. Anyway, we give that clarification to be mentioned tomorrow. Yes.
Item number 75. 76.
Lordship, I'm on behalf of the appellant. Lordship, one of the respondents has not yet been served, so we are seeking, let this matter be taken up next week.
Next week.
As per your point.
Learned advocate for the appellant says that service is not complete. The paragraph as requested, comma, let this matter be listed again on Monday. You are for the?
Respondent numbers 1 and 9.
On Monday, date diye dao. So in the meantime, let service be completed and affidavit of service be filed in court on the next date.
77. 78. 79.
Lord, 79, I appeal for the respondent husband.
You are for the respondent.
Respondent husband.
Oh, it's a matrimonial.
What is this application for? Can one?
Can one, I want to not press. That purpose is over. I have obtained injunction order in Can 2. And Can 3 filed for extension of
What was the prayer in Can 1?
That was the for stay of the operation of the order.
Very well.
That,
Hey, Can 1, not pressed. Huh? Learned advocate for the appellant says that he has instructions not to press this application. Huh? Dismissed as not pressed. Then what is Can?
Can 2.
Yes, Can 2.
My lord, injunction against the husband not to marry, and that has been granted for 8 weeks. That will come to an 7th November.
What is Can 3?
Can 3 for extension for till disposal of the appeal. Extension of the order.
Lord, we have not been served with any of the Can applications.
I have already served. I have given affidavit of service.
So you want an extension of that order?
This order was
Extension of
passed
the order, and my lord, appeal admission is required. That order.
without admitting appeal. How could an order be passed? Interim order? If there is no appeal in the eye of law, how can an order be passed in that appeal?
My lord, that is the that has been done. I think it is a mistake on the part of the
Statutory appeal, that's right. I mean, you don't need a formal admission. As a matter of right, you.
This is within time.
Can 3.
Lord, I'm ready with the main matter if Milords are.
So paper
Lords
book
could
is
take-
paper books are
Yes,
required.
that is.
Paper book has
Ready?
to be prepared.
No, has to be
However,
prepared.
Has to be
Yes.
prepared.
Paper book has to.
I just filed few days back this appeal I filed.
How soon can you file your paper book?
Within 2 weeks.
We'll extend the interim order till the last day of the next circuit.
Lord.
Till the last day of the next circuit. File your paper books within 2 weeks. It will be listed before the next circuit. And then take it up from there. An interim order was passed by a coordinate bench on September 13, 2024, restraining the respondent from remarrying any girl or contracting any marriage for a period of remarrying থেকে কোর্ট করো remarrying any girl or contracting any marriage for a period of 8 weeks from date or until further order oblique orders of this court, comma, whichever is earlier, stop, unquote. The unquote. Paragraph, এটা তুমি can 3টা নিচ্ছ। Learned advocate for the appellant oblique applicant says that the period of 8 weeks is due to expire on November 7th, 2024. Stop. He prays for extension of the interim order. Paragraph. We are of the view that since a coordinate bench passed the interim order, comma, it should continue. It should continue at least for some time more. And the appeal should be made ready for hearing in the meantime. Stop. Paragraph, learned advocate for the respondent, comma, in his usual fairness, comma, does not agrees with the suggestion of the court. Does not agrees with the suggestion of the court. Paragraph, let the interim order that is in operation continue till the last day of the next circuit. Stop. The appellant shall file requisite number of paper books, incorporating therein all papers that were available before the learned trial court, as well as the pleadings filed before this court, comma, within 2 weeks from date. Stop. That is all. Paragraph list the matter before the next circuit. LCR you record.
Yes.
Let the lower court records be called for. Let the department notify the appellant or her learned advocate once the lower court records arrive. Can 3টা disposed of? Sure. Can 1 or can 3 দুটোই চলে গেল।
Lordship, I am for the respondent. I was directed to file evidence in opposition. Lordship, kindly give me extension. Next week I can file this. That's my evidence opposition. Then he can file evidence.
Then next circuit.
Lordship.
We'll extend the time, then this will be listed before next circuit.
Lordship.
On the request made by learned advocate for the respondents, comma, time to file affidavit in opposition is extended by a week from date. Stop. Let reply thereto, comma, if any, be filed within a week thereafter. Paragraph, list the matter before the next available circuit bench.
Lord, 81, I'm appearing for the appellant, but I'm praying for next circuit because we are yet to file the condonation of delay. Only the memo has been.
Learned advocate for the appellants says that an application, appellant actor says that an application for condonation of delay is required to be filed. Paragraph as requested, comma, let this matter stand over till the next circuit.
$82. 83.
Item number 83, I am on behalf of the appellant. This is a second appeal, my lord. I have also filed a condemnation of delay application, my lord.
You have filed. Is it appearing 83? Yes, can 1. Have you served it?
My lord, I have served it.
Where's your affidavit of service?
One copy of that.
That will not do, madam.
I thought it will be heard by the single bench, so I made one.
Oh, that is correct. Second appeal, yeah, you are right. Yes. Hey, देखो,
83 बोलना.
देखो.
Shadun Jha.
An application has been filed for condonation of delay in filing a second appeal. Stop. The condonation of delay application is required to be heard by a learned single judge. Paragraph. This matter stands released from our list. Stop. Let the matter be placed before the appropriate bench.
84, 85.
Lordship, item number 85, Lordship, kindly keep this matter next week.
Next week, on for the appellant. On the request made by learned advocate for the appellant, let the matter stand adjourned for the week.
Lordship, item 87, appearing on behalf of the petitioner, Lordship. Item number 87.
Yes, yes. It's an appeal. There's no application.
Yes, this is an appeal, Lordship, in FMAT, challenging the order of the learned district judge Darjeeling. Act 8 is Lordship. Lordship, in this case, an application under section 8 was made before the learned district judge.
Where's your other side?
Lordship, I have served them. The affidavit of service is in the registry, is being affirmed, Lordship.
Oh, there is a caveat.
No, there is no caveat, Lordship. There is no caveat.
There was a direction to serve.
No, there was no direction. We have served it, Lordship.
So if there is no direction to serve,
We have just served it.
you have prayed for an interim order.
Lordship, we are praying to allow us the permission to sell the share of the minor. And
so that was rejected by the.
That was rejected by the learned district judge Darjeeling, and application under section 8 was made, praying for the said permission, but that was rejected. Now, Lordship, in that case, Lordship, in that regard, I'm relaying a judgment.
Sir, why are you starting arguing on merits? Other side has to be here.
Yes, Lordship. Lordship, but if I may just submit one thing, in the learned trial court below, the other side has given their no objection, Lordship.
No, this matter is required to be admitted.
Yes, Lordship.
So.
Better? 80?
Order 41.
Oh.
There was a formal admission order like
It is off. Fight it off.
Points of logic.
August 2024.
Yes, Lordship. That's when it was rejected, Lordship. The application under the Minority and Guardianship Act. Lordship, if I may. Lordship, the affidavit of service has been
Anyway,
affirmed.
we are taking the affidavit of service. And we will record also, there is no caveat.
Yes,
You have filed it within the period of limitation.
Yes, Lordship. It has been filed within the period of limitation, Lordship.
So for Act 8 is concerned, it will be FMAT.
Yes, Lordship. It's a FMAT, Lordship.
Sure. This first miscellaneous appeal tender will be heard on the following grounds. এখান থেকে ground 1 এগুলো ground যেগুলো আছে 1, 2, 6. Seven and 8. Paragraph. এগুলো ground গুলো দিয়ে দেবে এখানে। Which read as follows বলে দিয়ে দেবে। ইতিহাস also করতে হবে। Let notice of appeal be issued to the one respondent.
Yes, only one respondent, Lordship.
To the respondent. Top. Let lower court records be called for. Paper books will require to be filed.
No, Lordship, no.
Not necessary.
Informal paper book. Informal and may make affidavit of service may kindly be taken.
Affidavit of service টা নিয়ে নিও পুরাতে। File informal paper books so that all papers are together.
All right, Lordship.
Let the appellant file requisite number of informal paper books containing all papers that were available before the learned trial judge, as also pleadings filed before this court. Paragraph. List the matter before the next circuit bench.
Grateful, Lordship. Affidavit of service.
Mr. Shivaji's report is appearing for the appellant. My lord, will it be lordship's pleasure to take it up on 12th, my lord? He has asked me to make a request before your lord.
On the request made on behalf of the appellants, let this matter stand adjourned and be listed again on 12th. November 12th, 2024.
89.
My lord, in 89.
89 I am for the petitioner, my lord.
Yes.
I am for the respondent, my lord. I am being led by Mr. Pritam Das. My lord, he is not well, and there was a direction to file affidavit in opposition on behalf of the state, my lord. I don't know whether the state affidavit is lying with Mr. Pritam Das. So let this matter appear next week, my lord. Kindly.
On the prayer made on behalf of the state respondents, comma, let this matter stand adjourned and be listed again on Monday, date the other.
Deeply obliged.
Item number 90. 91. 92. 90.
Lordship, we are for the appellant. We are for the respondent, Lordship. Lordship, we are seeking for the time, Lordship. Learned Senior Advocate Kalyan Sarkar will be appearing in this matter. If your Lordship kindly allow to take the matter at 13th November, Lordship. I leave it on.
On the prayer made on behalf of the respondent, comma, let this matter stand adjourned and be listed again on November 13, 2024.
Grateful, Lord.
My lord, in this matter, Mr. Rajiv Mukherjee, Planet Council, will appear through virtually. On behalf of the appellant.
I am for the respondents.
Yes, where is he?
Rajiv Mukherjee. Rajiv Mukherjee, just 5 minutes back, he told me
Kindly pass it over for 5 minutes.
Sure.
94. In 94, my lord, it is a matter of service tax arising out of the judgment delivered by the state. My lord, service tax.
One second. Mrs. Lakshmi Township.
Lakshmi
This has-
Township.
This has anything to do with the Lakshmi Tea Company?
No.
It's a township in Jalpaiguri, in Siliguri.
Lakshmi Township in Siliguri, Matigara, Siliguri. Uttarayan.
Who are the Uttarayan? Who are the promoters? Mr. Dipankar Chatterjee?
Dipankar Chatterjee.
Huh?
Yes.
Released on personal ground. Acha, next circuit. Next circuit.
Next circuit. It is a matter of service tax matter. CGST.
He's family to me.
Yes. Next circuit. Next circuit.
No, next circuit.
Next circuit.
Dekho, we are not willing to take up this matter on the personal ground of one of us. Amar namta diye dao. Paragraph, let this matter be placed before the next available circuit bench.
Grateful.
For the state, I only got the petitioner lordship. Lordship, I am paying for 1 day accommodation because lordship, Mr. Ghosh is appearing in this matter. He is engaged in court number 2, lordship.
Yesterday also you plead for
Yes, lordship,
accommodation.
but he is engaged in court number 2.
Not today. Why don't you, who's for the state?
I am for the state.
File a report.
Well, I have the copy of the report.
You have a copy of the report, very well. Still not traced.
Still not traced, my lord. My lord, it has been long since this person could not be found. And various ads have been given in the newspapers and including in the missing persons bureau.
We'll consider what steps you have taken. Not today, he's paying for time, not today.
Yes, 96. 97, I am for the.
96,
96. 97.
96 the petitioner.
Yes, sir, 96, the petitioner did not appear.
Yesterday also did not appear.
Okay, let us see next.
Let us see. Yes.
My lord, 97, I am for the appellants, my lord. My lord, my pray for not this thing because I couldn't prepare myself. Otherwise,
Shivashi's course will be appearing for the responder. If you lordship can take it upon 12th.
Okay, 97, why this can what?
well, that's the stay.
Oh, stay application.
Yes.
So it is already admitted? This
Yes.
Second appeal is already
Yes,
admitted?
already.
So after admission, hearing is to be before the single bench. That is the rule.
Not kindly sense to this.
No, after admission.
Well, their condemnation appeal has already been allowed. Those are.
Yes, but so when there is an order of admission, there is a direction for filing paper books and.
Paper
LCR.
books have already been filed.
So how?
Second appeal is normally heard by single judge, by a single. Yes. You see, condonation is by single bench, admission is by division bench, then back to single bench.
Yes.
This is rather funny, but that is
Well, this is already admitted, I believe.
correct. That's what we are
Now it
saying.
should go to the single bench.
Now for hearing, it should go to the
Pending for
single
the
bench.
hearing, Mala.
We are told that, we are told that this
Paper books have already been filed. Paper books have also been filed.
that the second appeal has been admitted by the division bench. Stop. The appeal has to be heard by a single bench as per the rules and practice of this court. Paragraph, let this matter stand released from our list and be placed before the appropriate bench.
Grateful much.
Item number 98, Lordship, kindly keep this matter next Monday.
On the prayer made on behalf of the appellant. Let this matter stand adjourned till we take the other.
Lordship, I am for the appellant. Lordship, kindly fix the matter is Monday, your Lordship, the 37 of Arbitration Act. Your Lordship, paper book is ready.
Same order. Sunecho, same order.
100. 101. 102. 103.
For the petition respondent.
You are for writ petition and respondent.
Lordship,
Who is the appellate?
Lordship indicates to item number 100, Lordship. I am for the appellant.
100 who? Who's for the respondent?
Lordship, I have sent the copy memo of appeal, but and already the service report is in my hand. But Lordship may, in that case, Lordship may kindly fix up it on Monday, if otherwise convenient to your Lordship.
100 টা 1 day করে দাও। Yes, 103.
Deeply obliged.
Who is for the appellant? কি মুশকিল?
103.
Jalpaiguri municipality has preferred the.
The municipality.
Municipality also.
Jalpaiguri municipality has preferred the appeal.
What to do? What can be done? Till today we'll be lenient, not from tomorrow. Tomorrow, Gochang Fu. If they don't appear, if you don't appear.
104.
Not today.
105.
My lord, 104 and my lord, 104 and 105, my lord. I am for the appellant, my lord. Mr. Rudra will appear, my lord.
Who?
Rudra is appearing.
কিচ্ছু শুনতে পাচ্ছি।
Mr. Rudra is appearing, my lord.
Yes. What do you want? এই ভার্চুয়াল হিয়ারিং কোনোদিন কাজ করবে না। Yes, tell us.
In these two matters, I am appealing for appeal. But what happens last occasion when the matter was heard, one order has been passed on in respect of
দাও
these
দাও
two
ফাইলটা
matters
দাও তো।
on 22nd August.
No, it is the last rotation week, 22nd August.
You must see the order dated 22nd August 2024.
Hey, an order today, 22nd August.
There is a direction on the part of the principal.
Oh, a report was called for.
Yes, my lord. The report was called for. That report was not submitted as yet. So far, my knowledge is goes, my lord, that report was also not submitted before the register of this, my lord, the circuit bench. So, my lord, if your lordship wants to hear the matter without that report, my lord, my lord, I am ready to hear this matter. Your lordship kindly then fix a date of in the next week, and I will do that.
একটা বিরাট অর্ডার আছে আলটিমেটলি রিপোর্ট চেয়েছে answering all these questions ওনার ট্রাস্ট নিয়ে কিছু আছে this court principal of the ABNC college by answering the following only question করেছে report is filed before the registrar within 3 weeks made available কিন্তু আজকে report ফাইল হয় না This college is a party.
Yes, my lord. It is a party from the very beginning, but my lord, they have not taken it. They are not neither in the writ petition nor in this matter.
So you serve a fresh notice on the college.
Already I have said.
When?
Your Lordship, kindly fix the matter next week any day.
Read order dated August 22, 2024. Stop. A report was called for from the principal in charge of ABN SEAL, SEAL, SEAL College answering certain queries enumerated by a coordinate bench. Stop. The appellant tells us that such report has not yet been filed. Paragraph. Let a notice be served by learned advocate on record for the appellant on the respondents, intimating that this matter will be listed again Monday date on such and such Monday, when the respondents should be represented.
Gateful.
Hundred and six, Your Lordship, I'm appearing through virtual mode, Your Lordship. Your Lordship may be if Your Lordship may please to fix this matter next week, any day, Your Lordship, as per your convenience.
You are appealing.
I am appealing for the statement.
On the prayer made on behalf of the appellant, let this matter stand adjourned and be listed again on November 12th.
Grateful, Your Lordship.
Private response.
108. 109. 110.
I'm for the appellant. Matter may be hard because what happened, my lord, facts is that,
110.
yes.
Senior Counsel, Mr. Shoptangshu Basu, Your Lordship, on his ground, I'm praying for this matter to be fixed on Friday, Your Lordship.
This Friday,
This
he'll
Friday.
come physically.
Lordship.
My lord, yes, no, my lord, what happened, my lord?
You better not oppose that prayer.
No.
Mr. Basu will come and
I not then stroll on the corridor.
come back on Friday.
Yes, ma'am. No, what I've done, in the last occasion, we could just serve the board.
Serve in the
I
meantime.
always serve, had the AVTB,
On behalf of senior counsel representing the
respondent 12.
respondent number 12, it is submitted that the matter may be taken up on Friday date the Friday, 7 তারিখ। এই Friday 8 তারিখ। আজকে কত তারিখ? 5,
Yes, 8.
August 8. Stop. Let that be so. Thank you.
One of the appeal, there, I think there are two appeals conjointly together. One of the appellant already died in the course of incarceration. Total punishment was convicted by the trial court of 7 years. Already more than 5 years they are in custody.
So why didn't you apply for bail?
Actually, my lord, I have on last circuit I have been appointed by the Calcutta High Court Legal Service Committee.
So 5 years already undergone.
Already pardoned.
And 7 years punishment.
Punishment.
So that opportunity always you have.
Your lordship's direction, my humble submission, if their detention may be
a set off and they may fail.
That's how can we do?
See, if you want to pass an order on minutes, you have to hear the matter. But so far that bail application is concerned, within short period you can file that.
File a suspension of sentence application.
Yes.
We don't have to tell you Kashmira Singh.
Half of the punishment already suffered.
Not when will you file?
Tomorrow, man.
Then let this matter be listed again on Monday.
Monday.
Monday করে দাও. Also serve on the state.
Obviously, I will.
150, 160, 117, 118, 119, 120, 151, 122, 123, 125.
Kindly fix the matter for next week.
Yes, which one?
125.
125. You are for the appellant?
Record করে দাও on the prayer made on behalf of the appellant.
Is the appellant is in custody or on bail? Appellant is in custody. Which section?
Not aware of that, Your Worship.
Anyway, you take instructions. Not this week.
Let this matter stand adjourned for the week.
156, 127, 128, 129, 130, 132, 133, 134, 135, 136, 138, and
37.
I am on behalf of the applicant.
Yes, 136 and 137. Yes.
Okay.
Matter is ready for hearing.
Yes, ma'am. I am with the paper.
Okay, you are in custody.
I am on bail.
You are on bail. Yes, which section?
376D, ma'am.
76D.
Very good. My lord, because the victim did not say anything against the accused person.
We request the state's presence.
How were you convicted then? How were you convicted?
The convicted based on the statement of the victim, but the victim herself stated that she never identified, she doesn't know that she didn't identify the accused on the dock, as well as, my lord, the victim herself stated that she was not raped in the.
এটাকে pause করো.
What is
Nah, any matter where both sides are present.
My lord, in 93 matter, Mr. Mukherjee, Rajiv Mukherjee. Now he's in this on the screen, Rajiv Mukherjee.
Why don't you ask him to come? This virtual hearing doesn't really work.
It's very difficult.
Very difficult.
Lord, I have come
The
yesterday.
weather is beautiful here.
Yes,
Ask Mr. Mukherjee to come next week. Sure.
Lordship, I'm appearing for the respondent, casual workers.
It is the,
My lord, I have to go back.
I'm filing the affidavit of service.
He's represented. File it.
My lord, I'm for the respondents.
One respondent only.
No, my lord. 10. Because here they have not mentioned.
So you are against the order of the tribunal?
Yes.
Yes.
Against the order of the tribe.
What has the tribunal directed?
Directed that they should be regularized.
How can the tribunal direct that?
No, my lord, what happens with this thing is the light of Umadevi, they have not been guarded, but we have argued before the CAT that they should be regularized. The Umadevi judgment will not applicable here. So this is a regularization case, my lord, of the casuals. Lordship, admission said
Anyway,
Yes,
the
yes,
appellant's senior
Counsel
counsel is not there. When will he be available?
Uh,
Ask him to, honestly, ask him to come, do it physically here.
Lordship,
My lord, if my lord permits me, in that case, I can argue.
Yes, please argue
In that case, kindly fix it tomorrow.
tomorrow.
After going through the record.
Go, come prepared, do it tomorrow.
My lord, my lord.
That's where,